Okay, so we are joined today by Max Everett. First of all, welcome everybody to the CLE. We got a bunch of people attending online and a handful of folks here in person. Max was originally scheduled to meet us here in Houston, but he has had a bit of a family medical emergency, so he's going to be joining us online from, I think, North Carolina. Is that right, Max?
That's correct.
So Max is a Texas lawyer. He did undergraduate at the University of Texas at Austin, and his law degree, I believe, at the University of Houston. Is that right, Max?
That is correct. Good old Cougar High.
I want to make sure that we have. We're going to look at the feedback. I might want to give Max real quick. So Max is a Texas lawyer, but he's been working in Washington, D.C. for almost his entire career. He was the CIO of the Bush White House. He also held the same position at the Department of Energy. And he has done a ton of work for national security cyber events. And he's going to tell us a little bit about what he's been seeing with this interesting transfer of documents amongst the National Archives and the White House and former President Trump's home in Florida. And he's going to tell us a little bit about some of the laws that the federal government has for reporting cyber theft, cyber incidents, and situations in which the government can get their hands on client records, which is an area that I know nothing about. If you have any audio or visual problems today, please click the raise your hand and we will try and resolve those. But I think we're in pretty good shape. So with that, I'm going to turn it over to Max.
All right, I'm unmuted. Good afternoon. Got slides, just trying to make them big. There we go. The slides weren't much. They're just a little decoration here. Mostly I'm going to walk through stuff. So Kyle, thank you for the introduction. And again, I'm sorry, I always look for opportunities to be back in Texas. And unfortunately couldn't make it this time around. I'm sure Kyle will save me a few margaritas for my next trip. As he mentioned, I'm still a member of the bar there in Texas. I somehow managed to pass the bar exam back in 1997. So still a member of the bar in good standing there. I'm now in North Carolina, but spent most of the last 20 years in DC in a few different roles at the White House and other places, including as the CIO of the White House, was also CIO of Department of Energy, and spent a lot of time on cybersecurity outside of that. So I've seen a lot of these things, and obviously there's been a tremendous amount of interest with the PRA, the Presidential Records Act, and what the Trump administration does. So I'll give you a quick outline here. I'm gonna lay out a few of the relevant sort of legal and regulatory pieces that are around this. Some of you may have heard of, some of you may not. Then I'm going to give you sort of a walkthrough of modern history of presidential and federal records. That's primarily been electronic, but it goes in some other areas. And I think it's good to have a little of that history and know about that stuff. And then at the end, I am going to talk a little about just some practical reasons for you as a lawyer. You may never directly deal with federal activity, but it's still going to impact you in different ways. So we'll talk about that for a few minutes, and then I'm going to try and save plenty of time. Happy to take questions. I usually answer questions I shouldn't, and that's okay. So we'll walk through this. You know, the long and short of this is the government has never been very good at records management. As someone who worked in and out of federal government for 20 years, that has not changed. And one of the things you've got to know about is, you know, there's a lot of these different laws and regulations in place that you're going to want to look just to have for the background. And as I walk through this history, you know, you can go look, you may have figured out I've been a Republican appointee multiple times, but the law is the law. And so I'm going to be very bipartisan in pointing out the failures of multiple administrations in terms of records management. So one of the first laws you can think about just understanding federal records as a whole. It's the Federal Records Act, FRA, that was first passed in 1950. It's been updated several times. We'll talk a little bit about 2014. There was a very specific update that really, for the first time, formally talked about electronic records as something different. In 1978, the Presidential Records Act was passed. And that was, as you would expect, primarily in response to the abuses under the Nixon administration. Most of us know at least some of the stories from that, but the way that they attempted to hide records, handle records, and even after Nixon left the White House, the disposition of those records was very contentious. And so that's when the PRA was passed. And the short version of it is it's focused on records that are related to the constitutional, statutory, or other official or ceremonial duties of the president. And as you can imagine, that's very broad, and there's been lots of litigation and conversation about what that means. And we'll talk a little about that. The next one that's important for you to understand is FOIA, the Freedom of Information Act. I expect many of you may be at least somewhat aware of that. That was passed in 1967. And that was really focused on allowing citizens to get access to records, federal government records. There are certainly a large number of exemptions under that. And I will tell you, as someone who's worked in federal government, that the government is incredibly slow about responding to FOIA. Nonetheless, it remains a fairly powerful tool. And you're going to see it come up a couple times here as we walk through sort of the history of records, even at the White House. The next piece I'll mention very quickly here is the last one before we go into a little of the history, because this is going to definitely come around as we talk about the Trump administration, is classified records. For most of you who probably have never been around the federal government, you've heard of secret and top secret and classified records. There's an entire sort of schema and area of law around the handling of this, the pieces of it. That is primarily controlled by executive order. So it's a little unusual. In fact, probably one of the most unusual things when you look at classification is what we'd call the original classifier is the President of the United States. So theoretically, all classification of documents and information flows down directly from the president in his executive or her executive authority. And again, we're going to talk here about, and when we get to talking about the Trump White House, we're going to see there's a lot of unsettled things in that area because this is primarily from a constitutional perspective. The whole classification regime primarily does come from the executive. However, there are a number of legislative underpinnings and penalties that are laid out in U.S. code. So it is not a case where the president has complete sway and control over this. But it is very unusual because, as you would expect, because it's an exercise of, if you'll remember, your constitutional law, because it's under the executive authority, you get a lot of issues of, the balance of powers between the legislative and the executive, and in some cases the judicial, when it comes to matters of classified information. And we'll hit on a couple of those. So I've laid out a few. These are really the high points. They're the primary things that anyone in and around federal government, these are some of the big areas you deal with when you think about records. And as you moved into the era where we really started to think about records, because if you look historically, again, really before Nixon, most presidents basically just came in and they just took everything, right? Now you had presidential libraries and some of those things that already existed, but essentially all of that was done at the discretion of the outgoing president. They just it was all paper records. They just picked it up and took it. And it was sort of considered, in many cases, they acted as though they were personal records. Now, many of them did the right thing and established libraries and other things where those were shared, but that was typically how it was looked at. And obviously, Nixon, I think for good reason, the abuses of that administration changed that. And so as you come into the 80s and this whole scheme now, electronic records almost immediately become a problem, right? So really the very first area that we see that come up is in the Reagan administration. And so I don't know, I don't have to see in the crowd, so I don't know everybody's ages, but if you were around then, you will probably remember or have heard of something called the Iran-Contra affair, right? And you may recognize our good friend Oliver North. So the Iran-Contra affair was primarily about a trading of arms to Iran to get then money back that was used to fund the Contras, which was a rebel group down in Central America. In this particular case, because Congress had blocked the Reagan administration from directly funding or doing any activities with the Contras, this sort of workaround was cooked up within the National Security Council. Oliver North was sort of he's the face that everybody puts with it, but there were a number of senior Reagan officials who were involved in the process. And at this point in the early 80s, we didn't have the internet as we all know it yet, but you were starting to have electronic messaging. And so the National Security Council, the White House, had started using electronic messaging to do their conversations, especially with the National Security Council. So our good friend Oliver North here and some other key Reagan officials, when eventually the Iran-Contra affair was sort of exposed, congressional investigations were beginning, they actually came in and started deleting all those electronic messages. In some case, allegedly because they didn't believe they were covered by PRA. In other cases, arguably knowing that they were violating the law, but they actually came in and started deleting a lot of those electronic messages. Now, this is one of the areas where for me as a technologist who happens to be a lawyer, this is one of those where, unfortunately, we still see this today, almost 40 years later. People don't understand that just because you delete something one place doesn't mean it stops existing, whether it's backups, recovered hard drives. So actually, many of those emails were eventually recovered by congressional investigators, the FBI and other folks. So they were able to see things. Those came up later. So that whole scenario dragged on all the way into the George H.W. Bush administration. There were similar lawsuits that happened over email. And so one of the things that came up at this point, just from a legal perspective, that's still really not fully decided, there have been some lower court cases on it, is the White House lawyers, and this has been the case for both Republican and Democrat administrations, White House lawyers have typically tried to argue that the White House office, as the executive for the president, is not an agency, right? And the National Security Council is not an agency. That typically matters because if you look at the actual text of most of the legislation that's passed by Congress, it typically will say that it applies to departments and agencies. So the argument that White House counsels have made over many years now is they'll typically argue that the White House is not an agency and is therefore not covered by these laws, right? Which again gets into those conflict of powers issues between the legislative and executive branch. Why? What authority does the legislative branch? And I'm not going to pretend to be a constitutional law expert on that one, but as you can expect, there's been a lot of litigation on that, and I think it's still a very open area, but it's one that's typically come up. I share that for another reason that you're going to start to see as you go administration to administration, and that is that there is and I saw this firsthand, and I'll talk about it, but there is an impetus for each president, even when you have a change of parties, the new president that comes in office typically has a very vested interest in protecting the privileges of the previous president. And you can, of course, quickly understand why that's the case, because any argument that they make or allow to come through related to the president's privileges over their records, over their conversations and communications will immediately be applied to their administration. So what you've typically seen a number of times, you certainly saw it starting in the Clinton administration, and that's run right on through even to the Trump administration, is you will have presidents of the opposite party of their predecessor arguing in defense of their predecessor, right? Even despite any political differences. That's obviously, there's been a bit of a change of that with the Trump administration because of the specifics, but that's been generally a thing that you've seen happen over the years. So, you get through all this. There's a group called the National Security Archive. They've been involved in a number of lawsuits over the years specific to email. They filed lawsuits in the Reagan, the Bush administration, and others. And they're one of the reasons that those emails were eventually recovered. In many cases were shared, as they filed these lawsuits over the years, primarily under FOIA and a few other parts to make sure that those were available, right? And again, politics aside, the transparency and ability to see what the government's doing and why within some limits is I think most of us hopefully agree is a good thing. So you've watched that happen, over and over again. So, and the National Security Archive came all the way into the Clinton administration because, as you would expect, many of the litigation took many years. And in many cases, you saw the Clinton administration acting and the DOJ acting to defend the George H.W. Bush White House because they had their own desire to keep their communications controlled. So you come to this, and now you get in the Clinton administration. At the end of the Clinton administration, they really had one primary issue they ran into on email. And that was, at the end of that, one of the things that came into play here was, and some of these came out as a result of the court orders previously on the George H.W. Bush White House and others, they were required to keep backups of all their email, right? They were required to keep those as presidential records to be handled under that rubric. Well, one of the problems is in technology that people tend to rush things forward. They don't test them, they have problems. And so at the end of the Clinton administration, they ran into a problem, which was there were some accusations that then Vice President Gore was making fundraising calls and pitches from his official office, which you're not allowed to do. The president and the vice president have some unique ability to do political activity, even on federal property. That does not extend to anybody else. And there are limits to that. And one of the big ones is around fundraising. There was a set of emails that were related to this that were unfortunately, they were not properly backed up by the White House email system. Now, as you would expect, the Republicans immediately cried foul, claimed it was a conspiracy that they had been deleted and things. So one of the things I'll share with you, and I share this with you as a Republican, as I came to work at the White House later, almost every single person in the White House IT organization is a career federal employee, right? They're nonpartisan, they're not appointed. I got to work and meet with a lot of those folks, and the reality was they just screwed up, right? There was no grand conspiracy. But one of the practical results of that, and it's one, we all understand as lawyers, is if you get called in front of Congress to testify, you better have a lawyer with you, right? And so many of those folks, these career IT folks, were called to testify in front of Congress, had to spend an expensive amount of money to have legal representation when they went to testify before Congress, because of course they were under oath, and that could have been used against them. And I could tell you, I met some people who 7 or 8 years later were still paying their legal bills from the investigations that happened in '99 and 2000. So it was a painful thing for some of the folks that I worked with. One of the other sort of issues that was run into, and this is where we start to run into our friends at NARA. So NARA, if you haven't heard of it, and you probably have during this the Trump activities right now, that's the National Archive. They have primary responsibility for taking control of all these presidential records when a president leaves office, right? And so what the structure is, you'll have a presidential library. That presidential library can exercise the president's direction over those records, but the records are protected and maintained by the National Archive. So after 9/11, as there were starting to be conversations and hearings about what led to 9/11, there was an incident in which Sandy Berger, who had been Clinton's national security advisor for a number of years, was actually caught removing classified documents from a NARA facility in his pants. He actually did this a couple of times. NARA got suspicious and actually did a sting operation and tracked him down. And the only real result for him was he was disbarred. But that's a picture of one of the challenges of NARA is they don't have the best record of managing and protecting those documents themselves, but they're in charge of it. So now we jump forward to the Bush administration. So one of the biggest challenges in the Bush administration was that when they went forward with a new email system in about 2004, 2005. So it was right before I started at the White House. They moved to a Microsoft email system from an older one called Lotus Notes. The backup system that was used to capture those emails for presidential records, it didn't work properly, right? Just like it happened in the Clinton administration, it broke again. So the result was when there were congressional hearings and congressional records requests over a couple of things, the Valerie Plame incident, some other things, it was discovered that there were gaps in these emails that were saved. Now, this is an area that I know because I had to come back in 2008 as the CIO at the White House. And so I was responsible for essentially all the electronic records during the transition. And it took quite a bit of work and quite a bit of money, but we were able to recover, again, all of those emails because, as I mentioned, in the electronic era, things never go away, right? There are servers and hard drives and other places you don't think of where everything is saved and stored. So at the end of the day, we were able to recover all the emails that were pertinent and give them to NARA, right? And again, that would be my reminder to all of you as attorneys, right? As you're dealing with cases, as you're doing electronic discovery, as you're dealing with those things and someone comes back and tells you they can't find something, it was deleted, et cetera, it's always worth an extra look because the reality from a technical perspective is it's almost never really gone, right? It's still on a hard drive. It's still on a backup tape. It's still sitting around somewhere. And so there's often a lot of ways to go back and find that kind of information. So that's one just separately that's important for you to know as an attorney when you're dealing with discovering things like that. So now we'll sort of take a step forward then into the Obama administration. And again, as you would expect, I was there at on January 20th doing the handoff for the Obama administration. And the Obama administration was involved again with DOJ for several more years, defending in some cases some of the Bush administration's work that we did, to capture and collect all the data records, because again, they had a vested interest because they knew someday someone would be going after their email and records. So they were still defending that. A couple of important things happened really during the Obama administration around records, right? And again, you'll start to see many of these as they roll into the Trump administration. First, in 2014, there were Congress made some changes to the Presidential Records Act and the Federal Records Act. One of the most important ones, really, a lot of them were pretty rote, but it was the first time that there was a formal acknowledgement of electronic records as something unique and something that need to be uniquely managed and controlled. So that was a significant change because as you can imagine, if you heard, it was very ad hoc prior to that. That was when there was really more of a formal focus on those electronic records. One of the challenges that you had in the Obama administration was you started to see a lot more White House staff doing work on personal email, right? Because if you think back to that period of time, that was right when the iPhone came out, right? iPhones came out there in 07, 08. Everyone was starting to use iPhones, getting their own email. So it made it much easier for people to start using their own email for things. And frankly, you did see a lot of that at the Obama White House, was a lot of people were starting to do more things on a smartphone, right? And that first started with their own email, but that morphs, as we all know, and moved forward into text messaging and some other things. The second big case that I think everyone's aware of that happened during the Obama administration was, of course, Secretary Clinton's email issues at the State Department, right? So as you'll remember, you may or may not remember, but Secretary Clinton had her own private email server from which she did almost all of her official business at the State Department while she was Secretary of State for 4 years. So this is a great example, again, where even after these changes in 2014, right, which happened after Secretary Clinton had moved on, and they were partly in response to that, there was a lot of ambiguity from a pure legal perspective about exactly what and how to manage electronic records. Now, having worked for some cabinet secretaries, worked at the White House, a couple of things I'm going to tell you, frankly, about the Clinton email issue. At the end of the day, and again, I can say this as a Republican, I think DOJ probably made the correct call not to prosecute her. I don't think there was any way they could have gotten a conviction. I think there was too much ambiguity in the law at that point. right? And things that, you were so many years past when she was in office, I think it would have been very difficult for them to get enough evidence to get a conviction. So they probably made the right decision. Now a couple other things I will tell you. One of them was, if you look in that investigation, there were probably a dozen people on her mail server, right? So it wasn't just she was using her own mail server. It was, she had a dozen of her staff that were using that server, many of whom, in fact, I think almost all got immunity from DOJ during the investigation. And they gave the immunity without any proffer, which is fairly unusual. But they did what they did. I will tell you, it was almost certain, and we've seen this again across administrations, so this is not unique to Secretary Clinton, but it was almost certain that this was done to avoid FOIA, right? She had been in government before, she understood that. They actually set the server up prior to her being confirmed as Secretary of State. So it was almost certainly done to avoid FOIA. But again, Secretary Clinton was not unique in that. I've seen and heard of people across different administrations and parties, and we'll talk in a minute about that, using all sorts of methods to avoid being covered by FOIA or to avoid having their records captured. So that was, unfortunately, is not unusual. There are a lot of ways around that people have found. So I think that's a very difficult one. The other thing that did come up in the Clinton email was the fact that in many cases, there were in fact classified records in her email. Now, one of the challenges there was, in some cases, because of the work the State Department does, they were items that were classified, but classified things get leaked. They can come from other sources. And so there was arguments made that the items were given to them in a non-classified manner. There does seem to be evidence that people were retyping classified things into unclassified email, which is a fairly big no-no. Nothing was really done about that, and that was unfortunate, but we've seen that happen. So these are all the pieces that you saw, sort of the history and the things you saw come into place when the Trump administration came into office in January 2017. I'll share a couple things. Again, I was the CIO at Department of Energy from 2017 to 2019. So I was there as part of that Trump administration. I knew people at the White House, and I don't have any problem saying you certainly saw people who had been around, who knew what they were doing, who were avoiding things. I think one of the most unusual things that we see in the Trump administration, as you've heard me talk about, most of the focus on records and records management in the modern era in the last 30 years was primarily focused around electronic records, right? It was around email and electronic records and all the work that takes to manage and control that. What is, I think, very different in the Trump administration and the current issue is they took paper records. And I can tell you that's fairly unusual. Having worked at the White House myself, I've known people with other parties that worked at the White House. The fact of the matter was that those paper records have a lot of career federal employees controlling them. So I think it was extraordinarily unusual what we saw there. The picture I got up here, of course, is, this is one of the press pictures of, those fellows out there all work for GSA, the Government Services Administration. They really do a lot of sort of the bulk work for the government. And one of their responsibilities during a presidential transition is the White House will typically pack up boxes of things that are supposed to belong to the president, to the first family. They will take those boxes and they will move them. Right now, some of you may have heard stories or people talking about that GSA packed the boxes. That's inaccurate. I know that's inaccurate because I was there January 20th, 2009, helping to run the transition from the Bush administration to the Obama administration. So, and I know people at GSA, I've worked with them, they don't pack boxes, right? They take pre-labeled packed boxes. As you can see, they put them in a van and they take them where they need to go. They don't pack them, they don't inventory them. That's not their job, right? And so that's one of the stories you may hear out there that is, I can tell you because I've worked there, is not accurate. That's not the GSA's job. That is the job of the White House staff who did that work. So again, this is a very unusual case where you see paper records done. Paper records, again, historically have not always been handled well in government. But I will tell you, in my experience, seeing a bulk of records like that moved is very unusual, right? And so that's the first issue, and it's a fundamental issue, right? Because if you look, whether it's under PRA or FRA, one of the fundamental principles is that those records belong to the people, right? They belong to the government. So taking any of them, whether they're classified, not classified, whatever they are, it's a violation, if at the least, of the spirit of the law, if not the letter of the law, to take them, because they do not belong to those people. And so again, when you hear and understand the way that federal records are handled, right? You'll hear it said that all presidents have taken their records. Well, that's not true. NARA, the National Archive, takes records by law. They take the records, they hold them, they sort them, they manage them. The records are then released or available to the presidential library under that NARA guise, right? So for example, I know, because I talked to the people for the Obama administration and the Bush administration, NARA actually had very large secured warehouses in which all those documents were held, right? And they have certain standards for them. They're owned and maintained by NARA, right? The president doesn't own them or maintain them. The president typically then has access to them through custodians, right? So the president in writing can delegate his custodial rights to other staff members. Typically, they're a part of his presidential office. They have access to those records. They can make determinations. So for example, authors and other people can be given certain access to records based on the direction of the president. So it's important to understand all that. Now, probably the biggest and most concerning part of, this is a fuzzy picture, right? But this is one of the things the FBI put out in one of their filings, with the contents of the boxes that they found, right? And what you see in here, of course, is you see government documents with secret classification, documents with top secret classification, photographs with classification markings or without classification markings, empty folders with classified, right? Those are all very disturbing. So we've talked for a minute about, I mentioned classification. So one of the other things you're going to hear people talking about is the suggestion that the president, because he has original classification authority, he could simply, that he, quote, waved a wand and could declassify any classified document. So there's a couple of challenges to that situation. One of the things that's undecided in the law right now, and there's really not even a case law, is what is the actual process for the president to declassify documents? It's happened before. President Bush did it. President Obama did it. So we've seen, if you remember the story, President Trump actually shared some classified information with the Russian foreign minister. Now, no one disputed that, he was in a position right there where he had that right to do it. But when you look at things like a whole box of documents, an entire folder of classified information, the case law right now, and again, because this is handled under executive privilege, there's not really a lot of direction right now about exactly what the process would be to declassify. But one of the things we do know is you would have to take some step, right? Because the second that President Trump was no longer president, right, at 12:01 on January 20th, 2021, he was no longer president. At that point, he could not retroactively declassify anything, right? So one of the questions that really would come up, if and frankly when, because I expect DOJ is going to file some kind of charges involved in this, is going to be the question of, does the president have to affirmatively prove that he declassified these? Will he have to provide evidence that he actually declassified all these documents? And I think that's right now is somewhat of an open question, right? Which means that litigation is going to drag on for a while. There's a couple of other things that I'll share with you, just so you all know as you follow this story, to understand. While as I've said, most classified things are done under executive authority, not every classified document receives under that president's authority. And I'll give you two quick examples. So I worked at the Department of Energy, and you may or may not be aware, but we're responsible for the research, building, testing, and development of nuclear weapons. That doesn't actually happen under DoD. That happens Department of Energy through the national labs. And the Atomic Energy Act, right, which was passed many years ago, actually sets out a standard for documents related to nuclear weapons and material, right? And so you'll hear it's referred to as restricted data. It's a type of classification. It falls completely under legislative authority, right? Because it was set out in the Atomic Energy Act. That is something that the president, even with his executive authority, doesn't have the ability to declassify. There are ways to declassify it, to move it down, but the president cannot simply do that by fiat, right? Because that control is maintained from a legislative perspective. And now, given at least the public reporting that there was some nuclear related classified documents in Mar-a-Lago, that's going to present a very unique problem, because again, that cannot be by itself declassified by a president. Right? What's likely going to happen is that will end up turning into an executive versus legislative branch fight over that. But the law on that right now is somewhat clear. So that's going to be one of the interesting things that you may see as this Trump case moves farther along with DOJ. There's a second area of intelligence that also cannot be declassified by the president. And there's some evidence that some of this may have also been part of the records in Mar-a-Lago. So we very often have intelligence shared by foreign partners. If you're not in the intelligence world, there's a group called Five Eyes. So Five Eyes is Britain, Canada, Australia, and New Zealand. Those four, along with the US, are the Five Eyes. We have fairly extensive sharing of intelligence data among our 5 countries. Now, when that information is shared, it's shared under some specific restrictions, right? And one of them is when they give it to us, they control who we give it to, meaning we can't pass it on to another foreign country. We can't do certain things with it. And so one of the controls there is the president cannot declassify it because it's not our intelligence. It actually belongs to Australia or the United Kingdom or whoever gave it to us. And we do have similar sort of sharing in place with countries like Germany, Israel, and others, and Japan. So that's going to be another separate problem if some of that classified data from a foreign country is found at Mar-a-Lago in those documents. That's a significant problem, right? Not only legally, but just working on foreign affairs is going to be a problem as well. You know, the last thing I'll share about the Trump piece, again, we'll have a few minutes and I'm happy to take questions if I can answer them. But the last thing I'll mention, of course, and if you follow this from a legal perspective, probably the biggest risk that the president now has, as well as some of his staff, is they signed legal filings stating, you know, when they first turned over some of the documents NARA requested, they signed over legal documents that went to court saying that represented all the documents that were held there. And that clearly turned out to not be true. That is probably one of the other areas where I think there is significant legal risk for the president, as well as for a lot of the staff in his office. I'll share with you just personally, I know someone who's very close down there who was doing things for their office. And as soon as as soon as that raid happened, I was literally on the phone with that person because I advised them a year ago to not allow themselves be named a custodian of documents down there. Thank goodness they took my advice and didn't, but I was on the phone because I wanted to make sure that they were not at that risk. But I do think you're going to absolutely see, some potential charges filed against the people who filed those legal filings on the disposition of the records, because they're almost demonstrably false just based on what we know publicly. So I don't know the timing. I don't know what's going to happen next, but I would tell you from having worked in that world for 20 years, it's challenging. It's going to drag on for a long time because, as you've heard, there's a lot of ambiguity. But I would say that there's significant risk for the president and some of his staff down there with the handling these records. And again, I'll simply tell you that as somebody who spent part of my career protecting classified information, my hope is that it's taken seriously because it is, it represents a huge danger. So let me finish up real quick here with just a couple of other practical thoughts I have to share with you all, right? As you hear these stories and how the government's gone through this process and frankly, what a mess it is, A couple of things that I would tell you, you may have nothing to do with federal government directly, but there's a couple of things I would remind you of just to think about as lawyers and working with your clients. One of them, as I've mentioned, is, we're seeing all these new methods of communication, right? We're seeing texting, WhatsApp, Signal, that people are using more and more. And in many cases, let's be honest, people are using those to circumvent records management. Any of you who work with people in regulated entities, healthcare, financial, I've worked a couple of issues in my past career as a consultant with companies in regulated industries where you had people who are basically trying to go outside of the recorded system. We've seen a couple of cases of this with banks. For example, if you follow the LIBOR case, is a good example. So that's one for you to be aware of when discovery, right? If you're doing discovery, depositions and some other things, it's very good to understand what people are using. Is there a culture where texting is doing, regular business? Are they using apps like WhatsApp or Signal, whether it's formal or informal? It's important for you to think about when you're in those environments, because typically people are very unguarded and you can quickly get information that you couldn't get other places. So that's one to think about. I've already mentioned that federal record handling is sloppy at best. If you followed the last couple of years, the IRS has had a number of leaks of records. I don't think that's going to stop anytime soon. And with one of the recent pieces of legislation that was passed, the IRS is getting more money and they're getting more enforcement agents, right? And now they're looking at rules that are going to require reporting on Venmo payments and other things. That's more and more records going to the IRS. And very frankly, they have not proven themselves very good at protecting those records. So that's something for you to think about with your clients in terms of protecting them if you're working with anybody especially folks who are higher wealth and other things. You can't expect those records to stay private, unfortunately. The other big one I'm going to mention to you all, because it's in my world, is cyber reporting. So with legislation that was passed the other year, the Department of Homeland Security is going to have a major role now in requiring a very broad swath of critical infrastructure to report when they have cyber incidents. Now, the rulemaking around this is not completed, and it probably will not be done for at least another year, maybe longer. This is going to be significant, right? Because they're really expanding the definition of what is critical infrastructure, right? It may not apply to a mom and pop, but if you've got a client that's doing any federal work, if they're working with, electric utilities, if they're working with banks, healthcare, telecom, there are a wide swath of companies that are going to be swept up in this. And what it's going to mean is they're going to be required to report information on, if they've got ransomware payments, data breaches, security breaches. Those are going to have to be reported to Homeland Security. I will tell you, I've been a contractor and consultant on and off at Homeland for over a decade. They are really not good at protecting their information, right? And so you're dropping a lot of information in an organization that has not historically been good at protecting that information. So it's something you're going to want to think about with clients. Again, many of you probably don't work in cyber, but it's going to touch into all sorts of areas of businesses that people are just not ready for. So I would urge you to get educated on that, because it's going to have a spillover effect in all sorts of areas of business, right? And it's going to spill over into litigation, because inevitably people are going to want to try and get access to those records and information when things come up. And so I don't think, again, anybody's really thought that process through, but there are some protections for the data, but they are not ironclad. And so, as those reports start going to the federal government, FOIA is going to be your friend. You may be able to use FOIA to get information you could not get directly otherwise during discovery. So anyway, that's a few of the practical things that I think this implicates that I just wanted to mention as part of this. And with that, I'll wrap up sort of these comments, and I'll open up and just see if people had any questions. I'm very happy to answer as much as I can without getting in too big of trouble.
Max, can you hear me?
I can.
Is there any guesses or rumors out there about what might have been moved to Mar-a-Lago and why?
Sure. So a couple of the rumors that I've heard And some of mine, some of them you can read in the paper, some of them are because, as I said, I've been a Republican a long time. I know a lot of people. I know people that are involved in the move to Mar-a-Lago. I would tell you the rumors I've heard, and these comport with every story that I heard over the last 6 years about the present administration. The rumors I'm hearing primarily, one of them is around information on nuclear programs. Now that is, again, to me, very disconcerting because I spent 2 years protecting that kind of information. Right now, that doesn't mean it's pictures of nuclear weapons. What it very likely could be is classified documents assessing the North Korean nuclear program or the Iranian nuclear program. Those are two of the guesses I've heard from people. Unfortunately, the fact of the matter is when you understand those, you realize there are countries that would pay substantial amounts of money to have information on the Iranian nuclear program, right? Israel, Saudi Arabia, right? So that has led to a lot of speculation, right? Now, let's just be very honest. Whatever you think of President Trump, I don't think anybody would argue he wasn't a vain man. There's been some argument that what he kept were, quote, trophies. Our intelligence community does regular gathering of personal information on world leaders, right? Because you have to. You have to understand their health, their motivations. You have to understand their exposures and leverage. That's just the nature of the intelligence community. So there have also been some rumors that there were certain foreign leaders, Macron comes to mind, who President Trump was not a fan of, and he might have kept those documents, whether it was as a trophy or blackmail. Again, that's very speculative, but that's absolutely some of the speculation I've heard. Again, at the end of the day, even if you are, a President Trump supporter and a fan, you have to answer the fundamental question. These documents don't belong to him. They belong to all of us through the government, right? They're government property. And so you have to ask the question, even if you think all those things are just rumors, why did he bring them? They don't belong to him. They cannot be properly protected. I've been to Mar-a-Lago, right? It's just a big resort hotel, right? And we've already had cases of foreign nationals from China and other places wandering freely around that property. And that was when you had full-time Secret Service protection. So there was no reasonable way that those documents could be protected in that environment, right? It's the same challenge of Hillary Clinton's email server, right? I do IT for a living, and I could never properly by myself protect a mail server that was targeted by Russia or China. So I think that's the big concern, but that's some of the rumors, and we'll have to wait and see what comes out of the FBI and DOJ investigations.
If you know where Hunter Biden's laptop is, you blink twice yes or once for no.
Well, I believe that his laptop is back now in the hands of the government, if I'm not mistaken. But that goes back to what I mentioned before, right? Which is, and you all, I think, know this, but I would, as a technologist, I reiterate to you as lawyers, nothing has ever gone, right? He dropped off, the fact is he dropped off a broken laptop, and when he didn't come back and pick it up, somebody was able to get on it and get all the documents off there. And, those kind of things, it doesn't, broken is not always broken when it comes to tech. And so the reality is there are a lot of different ways to get access to those, whether it's in the cloud or on a hard drive or on a thumbstick. Documents always, people are just, we don't think about it. And those documents end up going all sorts of places you never thought of. So it's important to be a bit creative when you're doing electronic discovery, because you can find things that, people honestly didn't believe still existed. You can still find them.
Dennis, are there any questions from the folks online? You guys have any questions for?
Yeah, what's the street value on Iranian nuclear classified documents?
Oh, good question.
I mean, in all honesty, well, again, if you want to talk about speculation, let's be honest. Look at the amount of money that the Saudi-backed Live tournament is paying out. I mean, that's pure speculation, but that's the amount of money, I mean, to know the classified assessment of the Iranian nuclear program, which would include where those things were located, what their progress is, what they need to finish it off, who's supplying them, which is all probably part of those assessments. I mean, that's a, if you're Saudi Arabia and your mortal enemy is about to get nuclear weapons, how valuable would that be to you? $1 billion, $2 billion?
Eye out for 'em.
So yeah, that one is very disconcerting. Probably the most disconcerting one in my mind. The North Korean stuff is, there are people who are interested in it, but no one can really do anything about it other than the US. The Iranian one is a whole different issue, right? Between the Saudis and Israelis, you could probably get paid twice for that information.
So, this is kind of related. I'm kind of a big fan of presidential libraries. I think that's really an incredible opportunity to go see original documents and stuff like that. You think there will be a Trump presidential library that the National Archives will put this stuff in, or is that not really getting a lot of traction?
Well, I will simply say, knowing some folks down there, that has not, even before all of this started, that was not exactly the top of their list for setting up their office. And again, I ran the transition for electronic everything from the Bush administration, right? And I spent a lot of time working with them as we got ready to move and set up the presidential office in Dallas to get the documents and do all that. And so that was a picture of a well-run, thoughtful transition. This one obviously was the opposite for a number of reasons. My understanding from talking to a couple people who'd be in position to know is I don't think there's been any reasonable efforts forward on standing up sort of the post-presidential office or library that I'm aware of. Now remember, the documents still sit with NARA. There is still ability to get access to them. And so typically, there's a lot of back and forth on this, but typically it's sort of by default, like a 12-year hold before things start to come available. And then there's certain extensions and things you can do to extend that out further. So that's typically what it looks like. And then what most presidential libraries and offices do is, in the interim, through their custodians, they can give authors, historians, researchers access to particular areas or documents within that set of records. So, and as you would expect, most of them are they obviously want friendly people, but they'll have researchers and writers and other folks that will actually come in and do that kind of research. Now that would still be available even without a presidential library, right? And that's something separate the president has to raise funds for and do. But the documents themselves still exist. They're still held by NARA. They're still going to be accessible to a certain point, right? And so there will be, eventually, to your point, there will be access eventually to start to get a little more of a look historically at what went on within those documents over time.
George here brought up an interesting point, which is maybe they are not fundraising for a presidential library until Trump wins a second term.
I thought he was already in his secret second term. Oh, well, you mean next term?
Third term.
Well,
fair question.
Well, since my spam folder is filled with a lot of political fundraising emails, I have not seen any there specific to the library. So whatever reason, yes, they have not started raising the money for that yet. Either that or they're going to
shut down Trump University, because that would have been a great place.
Yeah, either that or they're going to announce it's in the Saudi Arabian desert, one or the other. But yeah, I haven't seen again much movement on it. But again, this is the good news. Again, I would give you, as messed up as the government can be on this stuff, the PRA does exist ultimately to try and preserve as many of those records as we can, so that at some point historians and researchers can start to look at it and put together what went on behind the scenes. Right. And so from that perspective, again, I think that's a good thing. That's important, that there will be some access to that, regardless of what President Trump or any president wants to do.
Unless there's some questions from our online participants, I think we'll just thank Max for his time. Anything online? Nope. Well, appreciate everybody participating and attending.
Thank you.
And Max, that was really, really interesting and not something we normally get to hear about. So thank you very much for cutting some time in your busy schedule for us.
Yeah, sorry I couldn't make it in person, but I'll grab a margarita with you next time I'm in town.
Sounds great, Max. Thanks very much.
Thank you, guys.
If anybody has any problem or your time isn't reported promptly to the state bar, please email me. If you haven't given us your state bar number, please email that to reception@herberttrial.com. We can make sure you get the time you are due for this presentation. With that, I'll say Merry Christmas, Happy New Year, Happy Holidays, and we'll have another one of these beginning again in February. Thanks, everybody.
Thank y'all.